Welcome to The Prescription, the Tax Policy Center's biweekly webcast on fiscal policy. This is one of a series of conversations with state, local, and federal government officials, as well as leading economists and other experts. I'm your host, Howard Gleckman, a senior fellow at TPC and editor of our blog, TaxBox. My guest today is Kathleen Quinn. She's a partner in the law firm of McDermott Will Emery, who specializes in state and local tax matters. She has an LLM from NYU and a JD from St. John's University School of Law. We'll be talking about the tax implications of the rapid growth in remote work accelerated by the COVID-19 pandemic, as well as some other important COVID-related state and local tax issues. Before we begin, our usual bit of housekeeping. We encourage audience members to submit questions in the Q&A box at the bottom of your screen. The event's being recorded and will be posted online at TPC's website in the near future. We're using captioning, which you can adjust or turn off with the live transcript button at the bottom of your Zoom screen. If you'd like to join the conversation on social media, please use the hashtag #LiveAtUrban. And if you'd like to suggest a future guest for The Prescription, just email us at info@taxpolicycenter.org. Katie Quinn, welcome to The Prescription.
Hi, Howard. Thank you so much for having me today.
Great to have you. Thank you. There's lots going on in state and local tax front, but let's start with a potentially important case that the U.S. Supreme Court is not going to hear. So I'm going to play law student, which I wasn't, and I'll try to very briefly summarize the case and then we can talk about it. So the dispute was between New Hampshire and Massachusetts over a Massachusetts requirement that New Hampshire residents who normally work in Massachusetts must pay Massachusetts state income taxes, even if they're working from home due to the pandemic. I hope I got that right. It raises a bunch of important state issues, but the High Court decided it would not hear it. So first of all, why was the case so important?
So this case I think this issue has always been an important issue, but it has become increasingly more important as people are teleworking from different states where their office is located. So, I will use myself as an example. I am based in our New York office. I'm actually here today, but for the most part, for almost all of 2020 and the majority of 2021, I worked at my home in New Jersey. Now, this issue really became the issue of kind of double withholding, or where are employees' wages taxable, has really been highlighted by the pandemic because people were working from all over. Usually people just worked in their office, but now, there's a lot of people are shifting towards remote work. So I'll use myself as an example. The question is, who can tax my wages? New York and New Jersey. Under New York's rules, they have this thing called a convenience of the employer test, sort of similar to what Massachusetts said. And what they say is if you are based in a New York office, if your office is primarily New York, but you work outside of the state for your convenience, New York is entitled to those wages. Now, in the past, states like New Jersey and the New Hampshires of the world, Connecticut, said, okay, it's not a great result for New Jersey and Connecticut, but the revenue impact probably wasn't that significant. Now, bring on COVID, bring on 2021, kind of the changing landscape. Now employees are working from home and more permanently. So now there's a lot more revenue to be lost from states like New Jersey. New Hampshire didn't lose revenue. They don't impose a personal income tax, but what they said is, part of what the appeal of New Hampshire is that we don't have a personal income tax. That's why some people move to New Hampshire, and that is, that's lost if those wages are going to be taxed by Massachusetts, because those employees, typically did work in the Massachusetts office. So I do think that this is, I think it's always been an important issue. I think that it's really at the forefront of the state and local tax debate now, though.
So it's a really important issue. It's been around a long time. The court was presented with a case and it didn't take it. So where does that leave us?
I think it leaves us in the same mess that we've always been in. As a practitioner, we get a lot of calls from our clients saying or asking, what do we do? Where, our clients, for the most part, are corporations or are the employers. Where do we withhold? But we also get the questions from individuals. Where are my wages taxable? So, from kind of a state sovereignty perspective, which seemed to be, the seem to be the reason maybe the court didn't take this case. But, from a practical perspective, states need guidance on what they can do. Employers need guidance on where to withhold. People need guidance on where their wages will be taxable, because right now we're sort of in a tangled mess. Each state has their own withholding, their whole personal income tax regime, and it's very hard to comply with. And now, I think what's becoming even more problematic is now we don't just have people that, they work in a New York office and they traditionally work from home from New Jersey. Now people are saying, well, I'm going to work from New Jersey. Then in the winter, I'm going to work from Florida, which is a bad example. They don't have an income tax, but, and then maybe for a month I'll go to Europe and it really becomes sort of a withholding mess. And I do think that employees are going to be subject to, income tax in multiple states. So where are we headed? The Supreme Court has made clear that it does not want to hear a case like this. We may see more attempts from states like New Jersey, Connecticut. They filed as amicus in this case. And then, we hope, at least the states hope that, or the practitioners, the employers hope that Congress steps in and kind of levels the playing field and makes this a less burdensome process for everyone. But, when you have the states like New York, Massachusetts, California, these states, they don't want these rules. They want to keep imposing the tax in the manner that they do. So I do think it's going to be tough to get support for bills like this.
So you alluded to this a little bit before, but I know other court observers have said that this was not a great case, in part because New Hampshire doesn't have a state income tax, and it's harder for it to prove it lost anything. And I guess the other reason that people have pointed out is that the Massachusetts guidance is scheduled to expire in September.
That's right.
So it would have been gone before the court probably heard oral arguments in the case. But as you mentioned, and you were candid in your full disclosure, there's a ongoing battle between states like New York and Connecticut and New York and New Jersey. And the New York rules are permanent, and Connecticut and New Jersey have their own state income taxes. So there's damages, there's a permanent rule. Do you think the court may be willing to hear one of those cases when it wasn't willing to hear the New Hampshire case?
That's an interesting point. And I do think that there is a better case for the court to hear the the New Jersey and the Connecticut case. It's, also right now, these states seem to be not trying to impose, taxes as well. So New Jersey, for the most part, will give a credit for New York tax paid because they don't want, their in-state residents to be subject to double tax. But as these states become more aggressive and say, we're going to just apply our own rules, and if people have to pay double tax, it is what it is, then I think it becomes more persuasive for the court to step in and say, okay, now individuals are being subject to 2 state income taxes. And, that's a lot of money, so I do think that maybe it becomes more persuasive then. And you're right, New York's rules have always been there, and they're not going away anytime soon. I don't think they are. So I do think that there's a more persuasive case there. But we've seen the court reluctant to step in on these sort of state versus state tax disputes. Arizona versus California was another, about whether California can impose their LLC tax on Arizona LLCs with no contact in California. The court didn't take that. So I do think that they're a little reluctant, but when we do see individuals start to be double taxed, I wonder if that will be a better case for the Supreme Court to step in.
So one of our attendees asked an interesting question. If a partner works from home or during a staycation in Europe, does the law firm need to have all partners now pay tax in that location?
I mean, that's the $1 million question. And as a partner in a law firm, I don't think I can, it's an interesting question, and it really depends on the state rules. There's a lot of uncertainty in that area, but yes, that's what I will tell you. That's what the law firms, that's what the kind of other types of firms are concerned about. And that's it. It's interesting. So when this first happened, or when COVID kind of first happened and states or employers started to develop policies, I actually had friends that said, we got notice that we're not allowed to work in any state where our firm doesn't have an office. And that is because the firms don't want to be subject to tax in these other states. So and there is a risk that they are subject to tax in these other states. So some employers, some firms are being proactive, others are the wait and see model. So we'll see.
So one of our audience asked the question that I was going to ask next, which is, so what would a congressional resolution of this look like?
There have been a number of proposals. I think, a good proposal would be to kind of just level the playing field, tell states or what they're allowed to tax. So, I think there are a couple bills that said if a tax or if an employee is not in the state for over 30 days, then you cannot tax those employees' wages. Basically setting a standard, because again, otherwise, if you are working, 3 days in Louisiana, all of a sudden Louisiana could tax your wages, and now the employer has to file a withholding return, and it becomes more of a mess. So I think something like that would be fair. Frankly, and this is just my opinion, I don't think that the convenience of the employer rule is fair, particularly when it's the way that it's been employed, during the pandemic. New York said we don't want people in the office. But now all of a sudden it's the convenience of the employee working from home. It doesn't seem like convenience to me, but, so I think maybe a rule disallowing that type of regime would be helpful. Really, any guidance that lets the states know what they can do so that we have a level playing field so that individuals and employers can comply with these rules. Because right now it's, and we've dealt with it. We're dealing with the employees that are everywhere, and it's impossible to comply.
So there's another solution, I guess. It's a little more ad hoc, but I live in Maryland, and DC, Maryland, and Virginia have had a long-standing agreement that avoids much of this problem.
Yep.
Is there any chance that other contiguous states would be willing to come to similar truces through interstate compacts? Could you imagine New York, Connecticut, and New Jersey working something out?
So the reason I'm saying no is because New York stands to lose the revenue. Because I believe the compact that you're referring to is each state taxes its own residents. Now, if New York said, okay, we won't tax New Jersey and Connecticut residents, they lose a lot of revenue because a lot of people commute into the city from New Jersey and Connecticut. Could they potentially work something out? Yes. I just think that New York has more to lose, so I think it would be more difficult getting them to the table. If New Jersey doesn't tax New York residents, it doesn't really, not that many people commute from New York to New Jersey. It's usually the other way around. So they would have to kind of figure it out, but I don't foresee that happening, at least with respect to New York. That doesn't mean that it can't happen in other states. I think Illinois, Indiana have a similar arrangement. So I do think that maybe that's the next step if states can work together. But again, they all have to be kind of on a similar playing field, and New York and New Jersey, Connecticut just aren't.
As many people have pointed out, Chuck Schumer, the Senate Majority Leader, happens to be from New York. Do you think there's really any chance that Congress is going to address this in the near future?
I think bills will continue to pop up, but I would not expect, while he's so influential, for a bill like that to pass.
So this brings up a kind of a broader issue, and there's always this argument about what's the purpose of taxation. There's kind of two principles that are at odds here. One is that taxes should raise revenue from anyone with some connection to a state, no matter how tenuous. And the other is that taxes should be based on the resources that are used in a jurisdiction. So by that standard, someone working in a basement of her home in New Hampshire uses no resources in Massachusetts while her temporarily abandoned office is located. No roads, no police, no fire protection, no health inspectors. So if that's the principle, why should she pay tax to that jurisdiction at all?
Yeah, I agree with you. From a policy perspective, I think that the amount of taxes that you pay, or that a company pays, or that the taxpayer pays, should be related to the benefits that you receive from that state. If you traditionally worked in a New York office and you benefit from the clients there, the market there, just kind of the New York environment, then maybe there's a case to be made that some of your, you do get some benefit from, New York being what it is. But I do think that New Hampshire has a much stronger case for taxing those wages because I guess New Hampshire again is a bad example. They don't impose tax, but let's say New Jersey has a better case for taxing those wages because they provide the police, the fire department, the roads, the infrastructure for that person to use. So, as people are more permanently always working from home, I think that, the state where they're working is the state that should be entitled to tax their wages. And a lot of states do that. I should just caveat, New York is kind of a weird example. There's about 5 states with the convenience of the employer rule. A lot of states say, we're going to tax you where you're working. So if you work 3 days a week in state A and 2 days a week in state B, state A taxes 60%, state B taxes 40%, and then we all go on our way. And to me, that's the most fair way for states to tax these wages.
It sounds like, though, what you're saying is whatever they come up with, just some rules so people know what to do and so people aren't double taxed.
Yeah, I think that's right. I think that's exactly right. I think employers and individuals, employees are really struggling with where their wages are taxable. And I'll be honest, it's hard to give advice because the answer is unclear. And, the risks are a lot. If an employee, says, okay, if the way I look at this rule, my wages are taxable in New York, New Jersey could say, well, actually, we disagree. And now you're subject to tax and good luck trying to get that refund from New York. And we're talking about individuals' wages. I mean, these are people's salaries. We're no longer talking about, a huge company that maybe has endless resources. We're talking about individuals, which I think makes the case for some guidance a little more compelling.
So we're seeing a different but related dispute now starting to bubble up over digital taxes. So my home state of Maryland recently adopted a first in the nation digital advertising tax, and it's already in court. But let's talk about the legal issues first. Opponents say the Maryland tax violates both the Internet Tax Freedom Act and the U.S. Constitution. Could you flesh out a little bit what those arguments are?
Yeah, so and just to be candid, your home state is imposing the tax, and my firm is the firm representing the taxpayer in court. And my colleagues in DC are handling the case. So that's really where they're really focused on that. But I'll focus on the Internet Tax Freedom Act. Essentially, what they're saying with that argument is, and this is a pretty high level, what the Internet Tax Freedom Act says is that you cannot impose a discriminatory tax on e-commerce or things provided over the internet. So basically, at a very high level, what this means is, and this is a federal law that prohibits states from imposing this type of tax. What that says is you can't, if you don't tax something that's done in person or, in the flesh, I'll say, then you can't tax it if it's done over the internet. So when we get to advertising, if the state doesn't tax general advertising, they can't impose a discriminatory tax just on digital advertising. So that's really the primary, and again, that was just a very high level. I'm sure my colleagues in DC would have a field day talking about this more, but that's really kind of the high level problem that we're seeing with the Maryland digital ad tax. And there's, I think, probably 10 or so other proposals that have popped up around the country. I know Connecticut has one, New York has one. So I think this Maryland case will certainly set some precedent.
So there's an interesting issue. So there's the legal issues, and as you said, your firm is representing one party in this. But beyond the specific legal issues, there's also an interesting policy issue, and it's in some ways, to me, it's parallel to the international dispute over digital taxes that the U.S. and the OECD and the European Union are trying to work out. In a modern economy where work, intellectual property, and capital are so mobile, how do states find a way to fairly tax individuals and businesses? I mean, where is this? You know, we used to talk about Nexus, and Nexus was a warehouse or a factory or a storefront, but what is it now? And how do you figure out where this income should be taxed?
Yeah, I mean, you're right in that, and I'll step back and say that I think the world changed so much faster than the state tax laws, which isn't surprising.
Right.
The laws move pretty slowly and tax laws move very slowly, especially state tax laws. But so I think that the Wayfair thresholds, frankly, were fair. If you have over $100,000 of receipts in the state, you can be taxed in the state. I mean, sales taxes are a bit easier, right? Because you're taxed on where your product is delivered. When you get to a service, then I do think that the states, we see the streamline and the compacts, but I do think that the states sort of have to come together and agree, we're going to source our services, or we're going to all tax these items in the same manner, because otherwise it does become unduly burdensome to businesses. And I wonder if that will be the next kind of issue that the Supreme Court down the line deals with. But it's not unduly burdensome to pay tax, but it may be unduly burdensome to pay tax when each state taxes your product or service differently, because now you have to figure out how this is sourced and taxed in 50 different states. But I don't know that there's a real clean answer when you have 50 separate states, and DC, that can impose the taxes pretty liberally in any, in any fashion that they choose, with obvious constitutional limitations. And I do think that I do think that potentially we'll need some guidance from the Supreme Court kind of defining what unduly burdensome means. And maybe that you have to file returns in 50 states, but you can't be subject to these kind of quirky different regimes in all 50 states.
Yeah, I wonder if in the federal level in the United States, we're going to have to go through the same kind of process that we're going through internationally, and come up with some sort of a unified tax system,
Yeah,
certainly a unified corporate tax system.
I agree with that, and I do think that states are looking at what's going on internationally to try and taking notes. And it's the problem is it's just a matter of you have to get all of the states on board, or at least the majority of the states on board. Otherwise, you'll always have outliers that will complicate things. But I guess to that end, we saw this with Streamline, with sales tax. If you have 35, or I think there's about 35 states, maybe 25 states in the that are streamlined states, that does help taxpayers figure out how to, it does reduce the burden if at least half the states or majority of the states, do things one way. I think that is helpful.
Yeah, it's interesting that in the international context, the many economists now say a destination-based tax is really the only way to do this. And one wonders whether or not maybe that's a solution in the U.S. too, that the tax is where the company earns its income.
We've seen that shift. We've seen that in corporate income tax, is where we went from cost of performance to market-based sourcing fairly quickly. And that, again, if all states are market sourcing in a similar manner, that does help taxpayers, one, avoid double tax, and two, kind of be able to, without expending a ton of resources, generally figure out where they'll be subject to tax. And I honestly agree with market sourcing. I think that does make the most sense.
So let me switch gears and ask about another COVID-related tax law issue that I know you've been watching. And that's a provision in the American Rescue Plan that barred states from using American Rescue Plan assistance to fund their own tax cuts. The law prohibits states from using ARP money, and I'll quote here, to either directly or indirectly offset a reduction in net tax revenue. So seemingly to test the law, Ohio passed an income tax rate cut, and last week a federal judge upheld the Ohio law. Several other states have their own lawsuits pending. So walk us through what's going on here and kind of what this is all about.
So, I'll say when this that language, we call it the clawback provision. When that language came out, I got calls all day saying state tax policy is done. I was like, well, that's not good, as I'm a state tax lawyer. That's concerning, but state legislatures are not allowed to do anything. I mean, we were dealing with unconstitutional laws. What if a state, because this didn't just apply to state laws, it also applied to administrative positions and stuff like that. So they said if a state strikes down a unconstitutional regulation, that's, if it leads to a decrease in revenue, that's a tax cut. And all of a sudden, does that trigger this provision? And so I do think that, that was a very broad provision, and it did have the potential to be very broadly interpreted. I do think that the guidance from Treasury was helpful in that it made clear that this is going to be interpreted narrowly. So, IRC conformity provisions. If a state says I conform to the IRC, but I don't want to conform to X, Y, and Z provisions because it's not in our, that doesn't work for our state, that's not considered a tax cut. So I think stuff like that, striking unconstitutional laws, not a tax cut. If for example, the digital ad tax violated ITFA, that would not be, and that was struck down. It was postponed at first, and now it's struck down. That's not considered a tax cut that would require Maryland to then pay back any relief funds. So I do think we landed in a better spot, but I will say that it definitely caused total havoc in the state tax policy world, as I'm sure people on this call have dealt with as well. But I think we're landing in a fairly good spot where I think that it's being interpreted as it was intended. If a state takes the funds, federal relief funds, and uses them to fund, just pure tax cuts, then potentially they have to pay those back. But I don't think it's going to be as broad as it was once.
So the interesting thing here, of course, is what Ohio did. They weren't really, to my mind, even close to the line. I mean, they said, yeah, we're going to do an across the board tax cut for everybody. This is not an technical administrative change. We're going to cut everybody's taxes. So they've really kind of raised the issue, put it in real focus. So what do you think happens? Do you think that this federal judge's opinion is going to survive, or is it contrary to the law?
I think it should survive. And I don't want to speak out of turn. I'm not too familiar with the whole issue, with the whole Ohio issue. They did come very close to the line. I will say this guidance, federal guidance, and if it's upheld, will be very good. It will give legislatures the confidence that they need to continue making policy. So overall, I think that it's good that this case that we have, obviously as a taxpayer representative, I think it's good that we have this case, but if it's upheld, I think it's just good for the state tax policy world, because it definitely allows states to continue making tax policy without concern that they're going to trigger this clawback provision.
So we have just a minute left. Let me just ask you though, it's very common that when the federal government gives money to states, that those funds come with strings. They often tell states what they can and cannot do. So why is this different?
Well, I think it's just different in that it was so broadly interpreted at first, and the language is broad. I mean, when you read it, to me, I read that as, oh wow, that the federal government just for the next 3 or 4 years or whatever it was, they commandeered state tax policy. They really hamstringed the legislatures and said, you can't do anything that will result in a net tax decrease, that will result in an effective tax cut. And when you start passing really broad laws like that, it sort of takes state tax policy out of the state's hands and gives it to the federal government, which I find extremely concerning. So I just think it was as broad, but I think that then Treasury recognized that and said, oh, we have to dial this back. We have to give some guidance that assures the states that we're not trying to take the reins out of their hands. And I think, it wasn't perfect, the guidance. I would have liked it to be clearer, but I think it did do that. And now we have the Ohio decision, which is also, helpful.
We are out of time. Katie Quinn, thank you so much for taking the time. It's a real pleasure to talk to you.
Thank you for having me. This was great.
And lots more state tax issues to talk about another time.
Oh,
Thank
for
you,
sure.
and thanks to our audience.